You see them in every shop, the friendly staff always on their feet, ready to help. But have you ever stopped to ask, why are they always standing? One government inspector did more than ask. They saw a problem, and they issued an order that would challenge the entire retail industry. The demand was simple: give your employees a chair. But Truworths, one of the biggest retailers in the country, refused. They argued their staff needed to be on their feet to serve customers, that providing chairs just wasn't reasonably practicable. So they took the Department of Employment and Labor to court to have the order thrown out. But in court, the case became about something much bigger than chairs. It became about a recognized health hazard: prolonged standing. The state argued that Truworths had never even done a proper risk assessment for this. The real question was, what does the law truly demand of an employer? The judge stated that the purpose of the Health and Safety Act is proactive, to prevent harm before it happens, not just react to injuries. After hearing all the arguments, the court had to rule on the inspector's power and the company's duty. And in a landmark judgment for every retail worker in South Africa. In the carefully curated world of high-end retail, every detail matters. The lighting, the music, the flow of the aisles. This is the world of Truworths, a titan of fashion retail in South Africa. It's a company with a history stretching back over a century, which today operates more than 800 stores across Africa and the UK, and in 2024 generated group retail sales of over 21 billion rands. Central to this massive operation is a specific in-store experience. Employees who are always visible, always on their feet, ready to engage. For years, this was an unquestioned standard, an accepted reality of the job at retailers like Truworths. A constant state of standing was simply part of the brand. But that reality was interrupted when a government inspector from the Department of Employment and Labor conducted a routine visit. This inspector saw the environment not through the eyes of a customer, but through the lens of the Occupational Health and Safety Act. They identified something that millions of shoppers had overlooked: a potential health hazard hiding in plain sight. The inspector concluded that forcing employees to stand for hours on end, day after day, constituted a real and foreseeable risk to their health. Following the visit, a compliance notice was issued. It was a direct, legally binding order. It didn't ask for a change, it demanded one. The notice required Truworths to formally assess the risks of prolonged standing and, most crucially, to provide suitable seating with backrests for their customer service assistants. For a company of this scale and prestige, this was no small demand. It was a challenge to their fundamental operating model. Truworths now faced a critical decision. Would they comply or would they fight? Truworths' legal challenge was a calculated two-pronged attack. They didn't just want to fight the order, they wanted to dismantle the very foundation upon which it was built. Their first line of attack was substantive. They argued that the inspector's demand was unreasonable. They explained to the labor court that the role of a customer service assistant is inherently dynamic. Employees must be mobile to greet customers, manage fitting rooms, and process sales. Forcing them to be tethered to a chair, they claimed, was not reasonably practicable. It would harm the customer experience and disrupt their established business model. They argued that standing was an intrinsic and necessary part of the job. But then, they opened a second front in this legal war, a procedural one. They questioned the authority of the inspector who issued the notice in the first place. Their legal team dug into the specific articles of the Occupational Health and Safety Act, examining the exact powers granted to inspectors. They put forward a sharp, technical argument. Did this specific inspector, on that specific day, even possess the correctly certified authority under the Act to issue such a sweeping order against a national corporation? This dual strategy was powerful. It meant they could win the case on the practical merits or on a single procedural technicality. The stage was set for a complex battle, forcing the Department of Labor to defend not only their position on workplace health, but the very legitimacy of their inspectors' actions. Faced with Truworths' dual front attack, The legal team for the Department of Labor knew they had to establish the undeniable truth at the heart of their case. This wasn't just about a disagreement over store policy. It was about protecting human beings from a known danger. Their argument pivoted to the powerful foundation of the Ergonomics Regulations. They methodically laid out the established science. Prolonged, static standing isn't merely tiring. It is a recognized ergonomic hazard with serious medical consequences. It is a known contributor to chronic lower back pain, varicose veins, cardiovascular issues, and a range of musculoskeletal disorders. These are not theoretical possibilities. They are the documented physical toll that such work can take on a person over time. The department argued that under the Occupational Health and Safety Act, every employer has a non-negotiable legal duty. First, to identify all foreseeable hazards in their workplace. Second, to assess the level of risk associated with those hazards. And third, to implement measures to either eliminate or mitigate that risk. They contended that Truworths had fundamentally failed in this duty by not formally assessing the ergonomic risk to their standing employees. From this perspective, the inspector's demand for a chair was not an arbitrary whim. It was the prescription of a standard, effective mitigation measure for a recognized occupational hazard. The case was now framed. It was a clear choice between a corporate operational preference and the prevention of proven, long-term human harm. The judge of the labor court was now faced with two distinct and critical questions. First, there was the substantive health and safety issue. Is an employer's desire for standing staff more important than the ergonomic risks involved? And second, the procedural question. Was the inspector legally entitled to issue the order? To address the first question, the court embarked on a deep analysis of the Occupational Health and Safety Act. The judgment affirmed that the entire purpose of the Act is proactive, not reactive. Its goal is to create a culture of prevention, stopping harm before it happens, rather than simply punishing companies after an accident or injury. The court dismissed the idea that an employer can ignore a foreseeable risk until definitive proof of harm, like a body of science, or a list of injured employees, emerges. The judge reasoned that an employer cannot design a system of work that inherently exposes employees to a hazard and then claim that mitigating that hazard isn't reasonably practicable. The duty to provide a safe work environment comes first. The court found the department's arguments on the health risks compelling and Truworths' arguments on the operational impact unconvincing. On the merits of the case, the path forward seemed clear. The court had laid out a powerful, precedent-setting interpretation of health and safety law, but the fate of the two specific compliance notices still hung in the balance, dependent on that one, nagging procedural question, and the answer would change everything. The final verdict was delivered, and on the surface, it was a shock. The labor court ruled in favor of Truworths. The two compliance notices were officially set aside. But the reason for this decision was what made the judgment so significant. Truworths didn't win because their arguments about chairs or customer service were correct. They won on the procedural technicality they had argued from the start. The court found that the inspectors who issued the notices had not been properly appointed under the correct section of the OHS Act at that time. A technical error, a procedural flaw, had decided the outcome of this specific case. However, that is not the true story of this judgment. Before delivering that final order, the judge dedicated the majority of the ruling to systematically dismantling Truworths' substantive arguments. The court explicitly stated that prolonged standing is a hazard, that employers do have a duty to perform ergonomic risk assessments, and that the arguments against providing chairs were unpersuasive. While these powerful statements were not the final, binding order in this case, they were placed on the public record for all to see. This is what's known as a victory in defeat for the Department of Employment and Labor. They lost this specific battle on a technicality, but they won the war on principle. The court's detailed reasoning created an unmistakable legal roadmap for the future, providing a powerful precedent for inspectors and a clear warning for employers. It affirmed that employee health cannot be compromised for operational preference.